Yes, in today's class, we'll start with law of tort. Many of you have read this law in your CSEET level, but however, what you're gonna learn in CS executive level is going to be sort different from what you have learned in your CSEET. Here we're gonna discuss the provisions in detail. This chapter has a weightage of 5 marks in the examinations, 5 to 10 marks. Okay, and it is easy to score as well. An interesting chapter hai, very interesting chapter. If you guys understand the concepts, you can aram se write in the examinations. Generally, they ask practical questions out of this. So what we will do, we will solve as many case laws as possible. Along with that, we'll try to understand the concepts as well. That. So let's start with the law of tort. Lesson number. Everybody, lesson number. Fine. Make sure you guys do participate and answers my questions. So law of tort. Law of tort. What is tort? First of all, let us understand what is a tort. Tort is a what wrong? All civil wrongs are not tort. Okay, correct. The answer is what? Tort is a civil wrong. There is a what wrong? It is not a criminal wrong. It is a what wrong? Civil wrong. We have discussed what is a civil wrong, what is a criminal wrong. Civil wrongs are a violation of individuals' right, whereas a criminal wrong is an offense against the society. And in case of criminal wrong, the remedy is the punishment of the one who does that wrong. Correct, right? Whereas in case of civil wrong, the remedy is what? Compensation or unliquidated damages. Tort is a what wrong? Civil wrong. What wrong? I'll explain the concept with the help of an example. Let's say there is a property. There is a what? Property. There is a property. This is a house. And in this house, a girl is living in this house. Tell me, does she has any legal right over the property? She has a right to privacy. Right to what? Right to privacy as well as what? Right to property. Right to what? Property. Can anyone trespass to her property without her consent? Because she has a legal right. What right? What is the legal right she has? She has a right to privacy. What right to what? Privacy. She has a legal right. Now what happens? A boy who? A boy enters the house. What he does? He enters the house of whom is going, and he goes to the house. House of whom? The girl. So he enters the house. Who enters the house? Boy enters the house. Without whose permission? Girl's permission. Tell me, is it an invasion of right of the girl? So it is a infringement. In the law language, we call it as what? Infringement. Infringement of whose right? Infringement of the right. Now, the act of this boy. What of the boy? Act. What is the act here? Entering the house. The act of the boy caused the violation of whose right? Girl right. Whose right? Because there is a violation of right of the girl, the law gives her certain remedies. Gives her what? Certain remedy. So she has a legal remedy. What remedy? Legal remedy. Who has the legal remedy? Girl has the legal remedy. She can evict him from her house. At the same time, she can also sue him for recovery of compensation. Recovery of what? Compensation. Because we know that where there is a right, there is a remedy. UB just EB remedium. Correct, right? Where there is a right, there should be a remedy. A right without a remedy is of no use. So she has a right to privacy. Somebody has invaded her privacy. Now she has the right to file a case against him for recovery of the compensation. Now this wrong done by the boy. Who did the wrong here? Boy or a girl? Boy has done the wrong. So this wrong done by the boy is called as what? Called as the tort. Everybody, it is called as what? Tort. And the one who had committed this tort is called as what? Tortfeasor. What feasor? Tortfeasor. Also called as the defendant. Called as what? Now who can file a case against him? Who is the girl here? Girl is the girl. So now she has a right to file a case. She has a what? A right to file a case. Now she is called as the plaintiff. She is called as what? She is called as plaintiff and he is called as the tortfeasor. She has filed a case against him for recovery of the compensation. Tell me, is the amount of compensation payable, is it agreed by the parties? No. Is it fixed in any law? No. It is given by whom? Court. Given by whom? That is why it is called as unliquidated damages. What damages? So who has a right to file a case here? Girl. The girl has a right to file a case against whom? Boy. Who filed a case? She can file a case. Can she file a criminal complaint or civil case? If it is a criminal trespass, she can also file a complaint in the court. Both the options are available. Okay, so it can be a criminal wrong as well as what wrong? Civil wrong. Now we are only discussing about the civil wrong. What wrong? Civil wrong. Now the girl filed a case. Who filed the case? Girl. Now because the girl filed the case, she is called as the plaintiff and the boy is called as what? Defendant. Tell me, is there any specific law? What law? Law, everybody, what law? Specific law to deal with law of tort? No, it is a common law. What law? There are two types of law, codified law and common law. What is common law, sir? Common law is based on judgment of the court. What of the court? Judgment of the court. Tort law is mainly based on judgments of the court. There is no act called as Tort Act in India. Are you guys getting it? We have a Companies Act. Which act? Which is codified by the parliament, but there is no law called as Tort Act. Tort law is mainly based, what based? Mainly based on what? Common law. It is a common law. What law? Common law is a law which is called as a judge-made law. What made law? Means the precedents of a court. What of a court? Precedents. What is precedents? Judgment of a court becomes a rule of law to be applied in a similar cases. What cases? For example, in one of the earlier case, a boy trespassed to the property of the girl. In that case, the court has given the compensation. That becomes a precedent. That becomes a rule of law to be applied in the similar cases. What cases? Similar case. That is what called as common law. Common law is famous in England. Most of the laws in England is common laws. They don't have much of written laws. But in India, majority of the laws are what laws? Written laws. But one of the law which is not not a written law or unwritten law is what? Law of tort. Law of what? Tort. So tort is a criminal wrong or civil wrong? Where the remedy in the common law. Remedy in the what? Common. The remedy is not in the codified law. The remedy is in what law? Common law. What law? If it is a Companies Act, the remedy is in which act? Companies Act. It is a codified law. Clear? So here law is a tort. Law is a what? Sorry, tort is a civil wrong. Tort is a where the remedy in the common law. Remedy is in where? Not in the codified law. Remedy in the common law is a suit for unliquidated damages. What damages? So where the remedy lies? The remedy lies in which law? Common law. And the remedy, one more remedy is what? Unliquidated damages. Everybody, what damages? Unliquidated damages. Is it liquidated or unliquidated? Unliquidated damages. Are you guys getting it? Yes or no? Now what is unliquidated damages, sir? This is fixed by the court or decided by the court. What by the court? Rebolo, what by the court? If the parties themselves requires or decides the amount of compensation payable, it is called as what? Unliquidated damages. What damages? Liquidated damages. She can claim it, but it depends upon the court. The court decides what is the amount of compensation payable. It can claim 1-2 rupees also. But it is a court who decides the amount of compensation payable. In case of contract, what happens, right? In the contract, we generally prefix the amount of compensation payable. Right now, if there is a breach of contract, we can agree that you should pay me 1 lakh rupees of compensation. That is called as what? Liquidated damages. What damages? Liquidated damages. In this situation, who gives the compensation? Court gives the amount of compensation. And one more reason why it is unliquidated damages, because you might have not suffered any loss. Still, court gives you amount of compensation. Liquidated damages are always reasonable in nature. What in nature? If you have suffered 1 lakh, court gives you 1 lakh rupees of amount of compensation. That is called as liquidated damages. But in case of unliquidated damages, there is no correlation between the loss suffered and the compensation given. You would have not suffered any of the losses. But still, because you have gone through the mental agony or any sufferings, the court can give what? Compensation. Even though there is no financial loss. What loss? Still court can give the compensation. That is the unique feature of what? Tort. Now you guys tell me, in case of tort, remedy lies in which law? Is it codified law or common law? Common law is a written law or unwritten law? Is it uh, made by the judge based on the what? Judgments of the court. What of the court? And the remedy is what damages? Unliquidated damage. Clear with this? But all civil wrongs are not tort. All civil wrongs are not tort. There are civil wrongs which are not called as tort. There are civil wrongs which are not called as what? Tort. Example, breach of contract. Breach of, that is also a civil wrong. I made a promise to you to fulfill the promise, and if I don't keep up the promise, it is called as breach of contract. Breach of contract is also civil wrong. Everybody what wrong? A breach of contract. What of contract? Is a breach of contract is also a civil wrong? Yes. A breach of contract. A what of contract? Breach of contract. Is it a civil wrong? Yes, it is a civil wrong, sir. Then the breach of trust. Breach of what? Is it a civil wrong, sir? That is also a civil wrong. Sir, equitable obligation. What obligation? Have you heard about quasi contracts? Quasi contract, finder of lost goods. If you find someone else's goods, you're supposed to give it back. All these are civil wrongs. All these are what wrongs? But these are not called as tort. So all civil wrongs are not tort. All torts are civil wrong. So tort means a civil wrong. What wrong? Other than breach of trust, breach of contract, and equitable obligations. What obligation? Equitable obligation. This is the definition given by the Salmond. Given by whom? Salmond. Can you guys tell me what is the definition of a tort? Tort is a where the remedy is in common law for unliquidated damages other than breach of contract, breach of trust, equitable obligations. It is what called as a tort. Civil law. Is a tort a codified law or uncodified law? It is not codified by the legislatures. Clear? Is it based on the judgment of the court? Yes, it is based on the precedents of the court. What of the court? Precedents. What is precedent? A set pattern which is set by the court. I will clear with this. This is the definition given by whom? Given by the Salmond, one of the important jurists in our legal system. Clear? So shall we start with the law of tort? Everybody, yes or no? Yes. Let's go. Let's go. Definition of tort. What is the definition of tort, guys? Salmond. According to whom? Salmond, not almond. It is Salmond. Tort is a what wrong? Civil wrong. What wrong? Tort is a civil wrong for which the remedy is in what law? Codified or uncodified? Uncodified. Where the action for what damages? Unliquidated damages. And which is not an exclusively the breach of contract. What of contract? If it is exclusively a breach of contract, it is outside the scope of what? Tort. Or the breach of trust. Breach of what? Trust. Or merely an equitable obligation. Nothing but quasi contracts. These three are outside the scope of the law of tort. So tort is a what wrong? Everybody? Civil wrong. And what is the remedy in case of tort? Liquidated damages or unliquidated damages? Unliquidated damages. Clear with this? Is it codified or not codified? It is not codified by the legislature and is based on the precedents. Based on what? Precedents. Are we clear with this, everybody? Now, what are the essentials of tort? What is the first one? Civil wrong. Below. Tort must be a what wrong? Civil wrong. Is it a criminal wrong? No. It is what wrong? Civil wrong. Second one. This civil wrong is not a breach of contract or a breach of trust. And the wrong is redressable by an action for unliquidated damages. Everybody what damages? Unliquidated damages. I hope you guys are clear with the concept of what is a tort. What is a what? In general, if you ask me what is a tort, sir, somebody does something or he omits from doing something. Either he does something or he omits to do something. Because of that, there is a violation of rights of whom? Other person. And that other person whose rights got violated has a right to remedy in the court of law. That is what called as A tort called as what? And in case of tort, the remedy is what damages? Unliquidated damages. What damages? If you ask me what are the essentials of torts, if you have observed the definition, what is the first thing? There should be a right. There should be what? What right? Legal right. What right? Did that girl had a legal right? Is there any violation of that legal right? And does she have a legal remedy in the court of law? That is what called as what? Tort. Called as what? And tort can be both positive as well as negative. There should be an act by person. Either you do something or you omit to do something which is your obligation. For example, maintaining the light pole is the obligation of who? BBMP. If they have not maintained it properly, and if a light falls on the somebody who is walking on the street, and if he is injured, is BBMP responsible or not responsible? Is it an action or inaction? Is it an action by BBMP or inaction by BBMP? Inaction by the BBMP, where they have an obligation of taking care of it. That is also considered as tort. Considered as what? If there is a clear provision or if there is a clear law to deal with this particular incidents, then there is no question of application of tort. Tort is a common law. What law? There is no codified law to deal with this kind of incidents. Are we clear with this? And to be a tort, it must be what wrong? Are all civil wrongs are tort? But all torts are? The tort includes breach of contract? Do tort includes breach of contract? No. Breach of trust and equitable obligation. But are they civil wrongs? Civil wrongs are not. But all torts are. And tort is a what law? Common, based on common law or codified law? Common law. Are we clear with this, everybody? Now let us discuss few case laws to identify whether it is a breach of contract or a tort. Or a what? Tort. Next one. What is the first case? National Bank of Lahore Limited versus what? Sohanlal Sehgal and others. Bank locker and safe deposit contents were stolen by the bank's manager. The bank manager has stolen the securities or the assets you have kept in the locker. Is it amount to a breach of contract or a tort? I have kept some goods or valuable jewelries in the bank's locker. Now it is lost. It is stolen by one of the persons in the bank. Is it a breach of contract or a tort? It's a breach of contract. Why? Because I entrusted these jewelries to the bank under a contract. We would be having a contract, right? Yes or no? And the remedy in this case is what? I can go and file a case under which act? Contract Act. Which act? For compensation, not under the tort. Is it a civil wrong? Is it a civil wrong? Yes. But is it a breach of contract? Yes. But not the tort. Because that wrong is happening, a wrong is arising out of contract. You would have clearly mentioned that the assets should not be misappropriated, should not be used. But the bank manager is using it, violating the terms of the contract. Then I can file a suit for compensation. Under which act? Indian Contract Act 1872. Because this wrong is happening out of contract or out of common law, like out of what? Contract. So breach of contract is not called as a tort. Not called as what? Tort. Next one. Yerlagadda Chinna Rattaya versus Donepudi. Termination or cancellation of contract. Is it a breach of contract? Yes. Only a person who procures a breach of contract can incur tort liability for inducement. Now what does it mean, sir? Listen, everybody. Now I will give a scenario, guys, to tell me which one is a tort and which one is a breach of contract. Now tell me, she is my employee. She is the employee of the week. I am the employer of the week. She is a good and honest employee. She works hard in the company and she's doing great for the company. Our company is like flourishing. Now she is the competitor. She is a what? Competitor. She want her to quit my company and join her company because she want the talent. She comes and say, you leave CSR company, I will pay you extra 5 lakh rupees. Because of this inducement, what she did, she left the company. Tell me, is this one breach of contract or a breach tort? I can sue her for breach of what? Contract. Compensation de do because you broke the contract. Correct, right? Yes or no? Can I also sue her? Can I also sue her? But do I have any contract with her? No. Did she do anything wrong? Yes. Because she solicited or she induced my employee to leave the company. That is a tort. This is not a tort, but that one is a yes or no? This is what? Breach of? That one is tort. If you guys read this provision, please, one more time. Only a person who procures a breach, procures a what? Breach of contract can incur what? Tort liability for inducement. The contracting party who breaches incurs what liability? Contractual liability. In our example, Priya is the one who breached the contract. Now she incurs the contractual liability and she incurs the what liability? Tortious liability. What liability? This is out of contract and this is out of common law. What law? Are you guys clear with this, everybody? Yes or no? Is tort and breach of contract both same or different? Different. But are they both civil wrong? All civil wrongs are not tort, but all torts are civil wrong. Are we clear with this? Third one, Ramaswamy Iyer versus Brahmaya and company. Breach of trust. Breach of what? Is equitable in nature. What in nature? Now, for example, let's say I create a trust. CSR trust. I appoint you guys to manage the trust. I have created a trust. What is the trust name? And I have appointed you to manage the assets of the trust as a trustee. And we have a contract. The way a trustee is appointed is by what? Contract. Now what do? You mismanage the affairs of the trust, going against the contractual terms. Now is it a tort or a breach of trust? Is it a tort or a breach of trust? Breach of trust. We have a clear contractual terms where I have entrusted the assets to you. You are my trustee. Is it a wrong, sir? Yes, it is a wrong because you are misusing the assets, sir. You are applying for some other purpose. But is it a tort? No. It is a what? What of trust? Breach of trust. So breach of trust is different from a tort. From what? Tort. Are you guys clear with this? Next one. Daljit Singh, not Diljit Singh. Daljit Singh and another versus Yogeshwar Prasad. This case happened in the year 2006. Even a civil wrong is not a all civil wrongs are not tort unless the appropriate remedy for it is an action for damages. Action for what? Damages. Any civil injury which gives rise exclusively to injunction, specific restitution of property and the payment of liquidated sums of money by way of penalty or otherwise is not a tort. All civil wrongs are not tort. Only a civil wrong where the remedy is what damages? Unliquidated damages. If the remedy is injunction, if somebody is trespassing to your property, trespassing to your what? Property. If the remedy is only injunction to stop him from entering to the property, it is not called as tort. To be called as a tort, there should be remedy for what damages? Unliquidated damages. What if the remedy is a penalty, fixed amount? Will that be called as a tort? Will that be called as tort? No. To be called as a tort, it should be unliquidated damages. What damages? It might be a civil wrong, but not a tort because it has what? Liquidated damages. What damages? Liquidated damages. So to be a tort, it should be a civil wrong, and in that civil wrong, what is the remedy? Unliquidated damages. What damages? Unliquidated damages. I hope you guys are clear with the concepts now. Yes or no? Yes. Next one. Next one. ST Saib versus Asan Ghani Saib. Entrustment of money and alleged misappropriation of that money. I give a money to you, and if you misuse it, is it a breach of contract or a tort? Breach of trust. Breach of what? Trust. Or breach of trust are considered as a tort? No. Breach of trust comes under the civil law. What law? We can file a separate suit for that. Yes. Any questions? Yeah. If you do it intentionally, that is called as what? Criminal breach of trust. It depends upon whether you have mens rea or not. Correct. See, wherever a wrong is involved, it can be both criminal wrong as well as what wrong? Civil wrong. In criminal wrong, the remedy is punishment. Civil wrong, the remedy is compensation. For example, accidental death. Or whenever accident happens, it has both the things. If you have done the accident intentionally, you are punishable. At the same time, because of your action, somebody suffered a loss, you are supposed to pay the compensation. So the remedy lies in both the laws. That is why having insurance is compulsory. Getting it? First case goes in the police station. They will prosecute you for committing an accident. Second thing, you should pay insurance money. If insurance money is not there, you can file a civil case. I should file a case in the motor vehicles tribunals for the purpose of recovery of what? Compensation. I cannot claim compensation in which court? Criminal court. Are you guys getting it? For compensation, I should go to which court? Civil court. And for punishing the offender, I should go to which court? Criminal court. Offender is punished by the state. They are the one who prosecutes the offender. I don't need to file a case against the offender. Who will file a case? State will file the complaint. Are you guys getting it? A wrong can be both criminal wrong as well as what wrong? Civil wrong. It can be a criminal breach of trust as well as what? Breach of trust. What is the difference, sir? For criminal breach of trust, you will be punished. Getting it? And for civil breach of trust, I will claim compensation for that if I have suffered any losses. Even the breach of contract. What of contract? Both it can be civil as well as what? Criminal if there was an intention to cheat. Are you guys getting it? Yes or no? But let's say I have entrusted this property to you. You misuse the property. Tell me, is it a breach of trust? Breach of trust. Plus, it is. I have two remedies against. What are two remedies? First, I want compensation. I want what? Is it a civil remedy or criminal remedy? Civil remedy. I have this remedy for every losses I suffer. At the same time, because you broke my trust intentionally, it will be considered as what? Criminal breach of trust. That who will prosecute? I will give a complaint and state will prosecute. Or I can make you punish for that. So the remedy for criminal wrong is punishment and the remedy for civil wrong is compensation. A wrong will always be what? Both. Some cases it can be only one. For example, assault. If somebody touches you without your consent, it is a what? Assault. Sorry, it is not a considered, it's called as battery. Clear? Here, there are two things are there. How many things? Two things. First, you can file a criminal complaint against the person. At the same time, you can also recover what? Compensation. Compensation is a civil remedy. Are you guys getting it? A wrong can be considered as both what? Criminal as well as what? Civil. For example, accidental death happened. What happened? A person has done the accident intentionally. A person is dead. Family members can file a case against the accused for recovery of what? Compensation. Civil wrong. At the same time, it is also what wrong? Can he be punished? Yes. Getting it? Right, so no. So wrong, it is can be both civil wrong as well as criminal wrong. Sir, how to decide whether it is a criminal wrong or civil wrong, sir? If it is defined in the criminal wrong, criminal wrong. If it is also defined in the civil wrong, it is considered as what? Civil wrong. If you have a right to compensation, below, it is what wrong? Civil wrong. At the same time, if it is defined as an offense under which act? BNS or any other criminal law, it is considered as what? Criminal wrong. What wrong? Sir, what if it is defined or provisions are made in both the laws? It is considered as what? Both the wrongs. Aresa, no. And you would be having how many remedies? Two. One, punishment. Another one is what? Compensation. Now, just because he is punished, does it mean he is not liable to pay compensation? No, he is liable to pay compensation. Getting it? Yes or no? Next one. Punjab National Bank versus Leader Wells Limited. The borrower alleges that bank negligently handled credit facilities and securities. Is it a breach of contract or a tort? Breach of contract. Negligently handling the assets is considered as what? Breach of contract. Not a tort. Not a what? Because the wrong is happening out of contract. Out of what? Contract. Contractual terms. Next one. Urban Improvement Trust versus Mohanlal. What happened in this case? Land was allotted by a statutory authority. There was a delay and deficiency in development and deficiency of delivery of amenities. Is it a breach of contract or a tort? Breach of what? Contract. They were supposed to develop the amenities. They did not do it within the prescribed time. You can go and file a case under which act? Indian Contract Act. Which act? Sir, why people will go under tort instead of going under contract act? Sir, in case of contract act, code gives liquidated damages. What damages? Means reasonable compensation, not compensation. But under tort, the sum of compensation may be what? Unreasonable. That is why we use it as unliquidated damages. What damages? Unliquidated. It's a discretionary power of the court. Are you guys getting it? So does tort includes breach of contract, breach of trust, equitable obligation? So tort is a what wrong? Breach of contract. Are all civil wrongs are tort? But all torts are? Are you guys clear with this, everybody? Next, one more example. Chennai Metropolitan Water Supply versus TT Murali Babu. Water supply was disconnected for non-payment. There was a non-payment of taxes and water connection was disconnected. Is it a breach of contract or a breach of, is it a tort? Breach of what? You're not paid the taxes. I'm going to disconnect the water supply. Is it a contract or is it a tort? Breach of contract. Breach of what? Yes or no? Next one. There must be a wrongful invasion of a legal right, not merely dissatisfaction with service. The relationship was governed by a statute. Governed by what? Are service conditions, not general tort duties. If it is not governed by general tort duties, it is not called as a tort. Next one. ICICI Bank Limited versus what? Prakash Kaur. Bank engage recovery agent. What agent? And if the bank engages recovery agent and if they do something which is within the contractual terms, it is called as what? Breach of contract. What of contract? What if they go beyond the contractual terms? They enter the house of the person which was not mentioned in the contractual terms for recovery of loan. That amounts to what? Trespass. Amounts to what? Trespass can be both criminal trespass as well as what? Civil wrong. Means you can file a complaint under the BNS. At the same time, you can sue him for recovery of compensation. Recovery of what? Trespass can be both criminal wrong as well as what wrong? Civil wrong. Yes or no? Same like defamation. Same like what? Defamation is both civil wrong as well as what wrong? Criminal wrong. You can be sent to jail. At the same time, you will be made to pay compensation. Are you guys getting it? Yes or no? Now tell me, what if the recovery agent goes to the house of the person and asks for recovery of money? Now the other person thinks he is mentally harassed because of this. Is it a breach of contract or a trust tort? Breach of contract. Breach of what? Because asking money is arising out of what? Contract. Now what if he apply force on the person, wrongful force on the person, the debtor? That amounts to what? Tort. Amounts to what? It's a crime as well as what? Tort. You're not supposed to touch anybody without their permission. If you do it, can they file a case against you for recovery of compensation? Yes. Can they file a complaint against you? Yes. You would be having both the remedies. What remedies? Are we clear with this, everybody? Yes or no? Next one. State of Haryana versus Santra. Woman underwent, Santra, whatever it is. Woman underwent sterilization in a government hospital. What is sterilization? Huh? You don't know. Sterilization means to. Huh? No, that is not sterilization. Sterilization is to make the woman infertile. That is called as sterilization. We have vasectomy and tubectomy. There are two types of sterilizations. Vasectomy for men, tubectomy for women. During Indira Gandhi period, she made it vasectomy, forced vasectomy for all the men. That is why she lost the election. How can population? Because they wanted to decrease the population. Sanjay, because of Sanjay Gandhi's recommendations. Yeah, they used to doctors used to come and catch them and take them to police station and do sterilization. What happened here? A lady underwent a sterilization operation, but even after sterilization, she got conceived. There is a negligence by whom? Doctor here. Now tell me, is it a tort? Is it a tort? Is the doctor liable to pay compensation? Yes, it's a medical negligence. What negligence? Is it a crime? Yes. Is the doctor punishable? Yes. At the same time, can that lady claim compensation for negligence? Yes. Medical negligence, both criminal wrong as well as the civil wrong, where you can also claim the compensation. Claim what? Are you guys getting how to differentiate between tort and a breach of contract? Next one. Loss of goods by railway. You have entrusted goods to the railway, but railway misplaced your goods. Is it a tort or breach of contract? Because that obligation of the railway is arising out of contract. Arising out of. Then comes ICSI, passenger injury due to negligence. The ICSI material. These examples are there in the ICSI material. What happened? No. What happened? Railway failed to provide adequate safety measures. They failed to close that passage. Because of that, a passenger got injuries to his legs. Tell me, is it a breach of contract or a tort? It is a general duty of the railways to ensure the safety of the passengers. They failed to exercise that duty and now they are liable to pay the compensation. Liable to pay compensation. So, in case of tort, the remedy is what damages? Unliquidated damages. Next one, medical negligence. What negligence? Causing injury. Causing what? It is both out of contract as well as general duty. What duty? Because both are involved, it is considered as tort. Considered as what? If it is exclusively a breach of contract, breach of what? Will it be called as tort? But along with breach of contract, if some other action is there, it is called as what? Tort. Called as what? Means some breach of general obligation. What obligation? General obligation. Yes or no? For example, I have made a promise to pay the money to you. If I don't repay it back, do you have a right to come and ask money from me? Yes. If you come and ask money from me in front of my relatives, can I get offended by this and file a case against you for defamation? No. Reza, no. But what if you start shouting in front of everybody, start assaulting me or applying physical force upon me? Will that be considered as punishable offense? Yes. At the same time, it is called as what? Tort. Called as what? Am I liable to pay compensation to you now? Yes. Clear with this? Yes or no? Now, I hope you guys are conceptually clear with the concept of tort. You guys tell me what is tort. Tort is a where the remedy lies in what law? And what is the remedy? Action for unliquidated damages. What damages? And these does not includes breach of contract, breach of trust, and equitable obligation. They are outside the scope of what? Tort. But are they civil wrong? Yes. But all civil wrongs are not tort. But all torts are. All torts are. Can a tort be both civil wrong as well as criminal wrong? Can a wrong be both civil wrong as well as criminal wrong? If it is a criminal wrong, what is the remedy? Punishment. Civil wrong, compensations. Are you guys clear with this? Next one. Difference between damage and damages. Singular and plural. Very good. What is the difference, Bhumi, between damage and damages? Huh? S is the difference. Then okay. See, damage is a violation of a right of a person. What of a person? Right of a person. Whenever a legal right of a person is infringed, it is called as what? Damage, a loss. What is damages? A monetary compensation payable for the loss suffered by a person. It is called as what? Damages. Called as what? Damages. Damage is different. Damages are different. What is damage? Violation of a right. Infringement of a right. What is damages? Monetary compensation payable for the loss suffered. What suffered? Is called as what? Damages. Called as what? Damage is a cause of action that gives you a right to file a case. And what is damages? Remedy for the cause of action. Bolo. Damage is a, everybody should tell. Damage is a cause of action that gives you a right to file a suit. Whereas damages is a remedy for the damage, the loss. So damage is different, damages are different. Which one is infringement of right? Which one is the compensation payable for the infringement of right? Damages. Which one is the cause of action? Which one is the remedy for the cause of action? Are you guys clear with this, everybody? Yes or no? A stage violation of right. Second one is remedy for the violations. Example. Can you guys read example, please? With the example, A enters B's land without what? Permission. Can you enter B's land without permission? No. 50 lakh, not 50 lakh, 5 lakh awarded for the medical negligence. Is that a tort? Yes or no? Damage is different. Damages are different. Next one. Liquidated damages and unliquidated damages. Tell me which one is predetermined and prefixed by the parties? Whereas which one is determined by the courts? Who determines the liquidated damages? Parties. Unliquidated one? Court. Which one is covered under the contract law? Liquidated damages. Which one is covered under the common law? Top. Unliquidated damages. Which one is pre-estimated? Which one is decided by the court? Unliquidated damages. And you guys tell me, in the common law, for a tort, what is the remedy? What damages? And in a contract, what is the remedy? Both liquidated as well as the unliquidated damage. I hope you guys are now clear with the definition of tort. We are just done with introduction of tort. It's a tort, guys. Tort is a what wrong? Where in common law, what law? What is the remedy? Action for unliquidated damages other than exclusive breach of contract, breach of trust, and equitable obligation. Clear with this? Next one. Liability against what wrong? Civil wrong. What wrong? Tell me, are all torts are civil wrong? But all civil wrongs are not? All civil wrongs are not, but all torts are. And which civil wrongs are torts? Where there is a under remedies under what law? Common law. What law? Common law. A civil wrong is a wrongful act. What act? That gives what liability? Civil liability. And remedied by the what? Law. It occurs when a person suffers a loss or damage due to the negligence or wrongful act of the another. That is act or omission of the another person. Loss of money caused by negligence is a what wrong? Damage to your property or reputation is also amount to what? Civil wrong. Failure to fulfill contractual obligation is also called as what wrong? Civil wrong. Victims of civil wrong has a right to sue the wrongdoer in which court? Civil court. What court? First of all, tell me what is civil wrong? The wrongful act or omission due to negligence or wrongful act of the another. That gives what remedy? Civil remedy. What remedy? And that creates what? Liability on the other person? Civil liability. What liability? Loss of money caused by negligence is a civil wrong. Loss to the property is a civil wrong. Failure to fulfill contractual obligation is a civil wrong. But all these civil wrongs are not. The main remedy for a civil wrong is damages. What is that? What is damages? Monetary compensation. Along with the other civil remedies. We have other civil remedy also. For example, injunction, restitution of property, self-defense. All these are what remedies? Civil remedies. What remedies are? But in civil wrong, most prominent remedy is damages. Damages. If it is liquidated, contract. Unliquidated, tort. Unliquidated is what? Tort. Civil wrongs includes following categories of wrongs. First one is what? Tort. Second one, breach of contract. Third one, breach of trust. And the fourth one, equitable obligation. What obligation? Equitable obligation. I hope you guys are clear with concept of civil wrong and tort. The conceptual clarity now. Are all torts are civil wrong? Are all torts are civil wrong? All civil wrongs are not. Which tort is a which wrong is a civil tort? Which wrong is a tort? Which wrong is a tort? Civil wrong. Where the remedy is in what law? Common law. Action for unliquidated damage, which is not exclusively the breach of trust or equitable obligation. Now, what if it is not exclusively a breach of contract? It is not exclusively a breach of contract. There is some other breach of duties involved. That is called as what? Called as what? Tort. Only if it is an exclusively a breach of contract. It is not a tort. It is what wrong? Civil wrong. What wrong? And in case of civil wrong, what is the remedy? Damages, along with some other remedies. In which court? What court? Is damage and damages both same or different? Which one is a loss? Which one is a cause of action? Which one is a monetary compensation? Damage. Clear with this? Yes or no? अब हम डिस्कस करेंगे what are the condition to be satisfied to be called as a tort. They might ask this question in the examination. A general condition to be satisfied to call an action of a person, a wrongful omission of a person as a tort. 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 Tort consists of some act. It consists of what? Some act or omission. What is act, guys? Positive. What is omission? Negative. When an omission is considered as a tort? When you have an obligation of doing it, and if you don't do it, it is considered as what? Omission. Omission is also called as what? Tort. If you don't do something and if I'm idle now, will it be called as tort? No. That omission will be called as tort only if I have an obligation of doing it. If I have an obligation of doing something, if I remain silent, it is called as what? Tort. So omission, that is also called as tort. So tort can be either action or what? Omission. Done by the defendant. Done by whom? Defendant. Whereby he has without just cause or excuse caused some harm to the plaintiff. The plaintiff. To constitute a tort, there must satisfy the following condition. If they ask in the examination, what are the conditions to be satisfied to call it as a tort, you should write first what is a tort. Then you write what are the condition to be satisfied. Condition to be. First condition is what? Wrongful act or omission. Arey bolo, wrongful act or omission. A person has done some wrongful act or a omission of doing something. Second one is what? There is a legal damage. What damage? What is legal damage, guys? Violation of a legal right. What right? Legal right. And the third one is what? Legal remedy. What remedy? The three essentials to be satisfied to call an act or omission of a person as a tort. What is the first one? Wrongful act. Second one? Legal damage. Third one? Legal remedy. I want everyone to repeat one more time. What is the first one? Wrongful act or omission. Second one? Third one? Legal remedy. If these three conditions are satisfied, it is called as a tort. Otherwise, it is not a tort. Tort is a what wrong? What wrong? Now, I hope you guys got conceptual clarity with respect to what is a tort and what is a breach of contract. Done? Let us discuss one by one. Before I discuss the concept, I want you guys to tell me what is the wrong committed here. Just go through it. Flying over the house is not a tort, right? Flying through her house. Okay. Okay, so now tell me, is it a tort? Why it is a tort? You guys apply this to the given case and tell me what are the conditions satisfied or not satisfied. What is the first right? What is the first condition? Wrongful act or omission. Is there any wrongful act here? Is there any wrongful act? What is the wrongful act? Is there any trespass? Who trespassed here? Somebody. That is not me. Does it look like me? No, it's not me. Is it a trespass? Yes. Wrongful act. What act? First, second one. Legal damage. What damage? Is there any legal damage here? What is the legal damage? Right to privacy, property. Like there is a trespass to the property. Whose property? This lady property. Correct, right. Second condition satisfied. Third one. Does law gives her any remedy in case of violation of the right? Yes, she can file a suit for compensation. Suit for what? Because it satisfies all the three conditions, it is called as what? Yes or no? What is the first condition, guys? Everybody? Wrongful act. Second one? What damage? Third one? Does it satisfy all the three conditions? It is called as what now? Tort. Let us discuss one by one. What is the first condition to be satisfied? Wrongful act or omission. The first essential ingredient in constituting a tort is that person must have committed a wrongful act or omission. Every person whose legal rights, what rights? That is right to reputation, right to bodily safety, freedom, right to property are violated without a legal excuse. What excuse? As a right of action, right of as a right of action against the person who violated them, whether loss results from such violation or not. That is the most important thing. Did she suffer any loss because I entered her house? But is there any monetary loss? But can she still claim compensation? Because she has suffered or because her right got violated, her right is infringed. So what is the first ingredient of a tort? There must be a wrongful act or omission. So every person who has a right to privacy, right to property, right to reputation, if it is violated, they have a right to file a suit in the civil court whether they have suffered any loss or not, because it is based on the principle ubi just ibi remedium. What is ubi just ibi remedium? Where there is a right, there is a remedy. Bro, where there is a right, there is a remedy. Legal damage. There should be a legal injury. What injury? Or invasion of a legal right. In the absence of infringement of legal right, most important. If there is no violation of a right, even if it have suffered the loss, it is not called as a tort. There should be a violation of right. Violation of what? It can be property, or it can be privacy, or it can be a reputation. Getting it? Without a violation of right, can that be called as a tort? Can that be called as a tort? No. There must be violation of what? Where there is a right, there is a without a right, is there any remedy? No. If there is no right, can you claim compensation? No. Even if it have suffered a what? Loss. And we will understand this with the help of the legal maxim. What are maxims? Where there is an infringement of legal right, an action lies even though no damage may have been caused. Is there any damage caused to the house here? What is the damage? Where is the damage caused? No damage is caused. But is there any damage to the right? Because there is a damage to the right, she can claim the compensation. Claim the what? Compensation. Are we clear with this, everybody? And we have two maxims. How many maxims? I will give the maxim. Listen, everybody. Damnum sine injuria. Bolo. Injuria sine damnum. Bolo. Injuria cum damnum. Bolo. There are three, but in your syllabus you have only two, but I'll give one more for the purpose of conceptual clarity. Clear? What is the first one? Damnum sine injuria. Damnum matlab hota hai damage. What is damnum? Dum dum mallappa. Damnum. What is that? Damnum, not dum dum. Don't write dum dum. It is what? Damnum. Damnum sine injuria. Artha in injuria. What is damnum, sir? Damage. Right, violation of a right. We know what is damage and what is damages. What is damage? Infringement of legal right. What is damages? Compensation payable for the infringement of legal right. So damnum is damage. What is damnum? Damage of right. Damnum sine injuria. Sorry, damnum sine what? Injuria. Any loss. Any what? Loss. Without infringement of right. Without what? Infringement of right. Injuria means Injury. Injuria means what? Injury. Tell me, will that be considered as a tort? No, it will not be considered as what? Tort. If there is just a damage, a loss, physical loss, but without violation of what? Right. It is not called as a tort. Damnum sine means what? Without. Without infringement of legal right. Without infringement of what right? Will that be called as tort? No. Next one is what? Injuria sine. What is injuria sine? What is injuria? Infringement of right. What of right? Sine means what? Without. Sign means without. Damage means what? Loss. You might have not suffered any physical loss or financial loss, but still because there is a violation of your right, it is called as tort. So damnum sine injuria is not a tort, but injuria sine damnum is a tort. Or injuria cum damnum is also what? There is an infringement of your right. Plus there is a loss as well. It is called as injuria cum damnum. You know? Is it a tort? Damnum sine injuria. Injuria cum damnum. Injuria sine damnum. Injuria sine damnum. Yes. Damnum sine injuria. Injuria cum damnum. Which one is a tort? Injuria sine damnum. Means infringement of right without the loss. Without what? Loss. Yes or no? Now tell me in this lady example, did she suffer any financial loss? But is it a tort? Because there is a injuria. There is a what? Any injuria without a damage is called as what? Tort. 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 Are you guys clear with this? Read damnum. It means a harm or a loss or a damage in respect of money, comfort or health. One more time. It's a harm or loss in respect of what? Money, comfort or health. What is injuria? Infringement of a right conferred by the law on the plaintiff. Sine means what? Without. The maxim means that in the given case, a man may have suffered a damage and yet have no action in the tort because the damage is not an interest protected by the law of tort. Then what is the interest which is protected by the law of tort? Right. Injuria is what? Protected by the law of tort. Yes, please. Compensation payable. All infringement of right will not be called as a damage. See, if there is an infringement of right, you have a right to legal remedy. What remedy? Correct, right. So damage is a loss. Damage is a what? A loss. And that can be loss of what? Legal right. What right? Legal right. Or loss to the what? Property also. But also property also. And when the compensation is paid for this wrong, it is called as what? Damages. Called as what? Damages. Damage includes both infringement of right of a person or a loss to the property as well. Loss to the what? Property as well. Yes or no? But here we are saying damage means what? Loss to the property or persons. That or not the infringement of right. Not the what? Infringement of right, because we're using the word called as what? Injuria. It's a Latin word. What? What? So we should take into consideration infringement of right. What of right? Not the loss, not the what? Loss. What loss? It can be physical loss or it can be financial loss or a property loss. That is not important. Only what is important here? Infringement of right. What of right? The violation of a legal right. What right? Legal right. Because tort law protects only a legal right. Because where there is a right, where there is a what? There is a remedy. Without a right, is there any remedy? No. So it is only the infringement of right. What of right? The loss of right which is covered under the tort law. What law? Tort law. Are you guys clear with this? Yes or no? Yes. Therefore, causing damage, however substantial to another person, is not actionable in law unless there is also violation of everybody what right? Legal right. If there is no legal right, just because you cause a loss to somebody, financial loss or property loss, will that be called as tort? Will that be called as tort? Answer is no. To call something as a tort, there must be what? Infringement of right. What of right? Got it? Yes or no? What is the first essential of a tort? Wrongful act or omission. Second one, what right? Legal damage. And for legal damage, we have how many maxims? What are two maxims? Damnum sine injuria, injuria sine damnum. Which one is it on? What is injuria sine damnum? It means injury without a damage. Where there is no damage resulted, yet it is an injury or a wrong in a tort. Where there is an infringement of legal right. What right? Not resulting in the harm, but plaintiff can still sue in tort. Some rights or interests are so important that their violation is an actionable tort. What tort? Without proof of damage. Means that very act itself is gives a cause of action for recovery of compensation. Clear with this? Even there is no loss. No what? Loss. Third one. When there is an invasion of absolute private right. What right? There is an injuria and the plaintiff action will succeed even if there is no damnum or damages. Damnum or what? Instead of that, it should be used what? Damage. See, they are distinguished between damage and damages for the purpose of compensation. For the purpose of what? Compensation. But if you go with the normal definition of dictionary definition, they interchangeably use the both, right? Yes or no? Clear with this? Now you guys tell me, without a loss, can there be a tort? Without a loss, monetary loss, can there be a tort? Yes or no? Without a violation of legal right, can there be a tort? Even if a person has suffered the loss. Suffered what? Tell me in a tort, what is most essential? Is it violation of right or loss? Violation of the, not the loss. Understood? So what is the first essential element of a tort? Wrongful act or omission. Second one, legal damage. What is legal damage here? Violation of a legal right. What right? Legal right. An act may not be a tort even if it is causing harm or any loss to the reputation or property of a person unless it is violation of a right of a person. What of a person? Right of a person. Are you guys clear with this, everybody? Yes. Hmm. Correct. It is a violation of right. You are damage the property of somebody. In case of tort, intention doesn't matter. There are few offenses where intention doesn't matter. That is the major difference between a crime and civil wrong. For example, traffic violations. You may be doing without any intention of doing it, but still it is considered as what? Tort. Getting it? So mens rea is different and tort. There is no requirement. There are offenses where mens rea is required. Sorry, there are torts where mens rea is required. At the same time, there are torts where what is not required? Mens rea is not required. For example, you are in a antique shop. You're just inspecting it. By mistake, it fell and damaged. Are you liable to pay compensation for that? Are you liable to pay compensation for that? Did it happen intentionally? But are you liable to pay compensation? Yes or no? Did they had any right over there? Yes, they had a right to property. You damage their property. Now there is a loss as well as violation of right. Violation of what? Is it a tort? Is it a tort? What is the first essential element of a tort? Everybody. Wrongful act or omission. Second one. Legal damage. Third one. Legal remedy. What remedy? The third condition of liability for a tort is legal remedy. What remedy? Means the law should give some remedy to you for the purpose of for the violation of that right. If there is no legal remedy, what remedy? Wrongful act must come under the law. Come under the what? Law. The main remedy for a tort is an action for what damages? Unliquidated damages. Keep this in mind. The main remedy for a tort is unliquidated damages. What damages? But in addition to that, court may also give some other remedies. like injunction, like what? Injunction, specific restitution of property. Like this, there can be other remedies as well, which are given even in case of breach of contract. But the main remedy, what remedy? Or that main ingredient which distinguishes civil wrong from the tort is that in case of tort, the remedy is what damages? Unliquidated damages. Everybody below, unliquidated damages. Are we clear with this? Yes or no? The main remedy, what remedy? अरे बोलो what remedy? Main remedy for a tort is an action. Is a what? Action for what damages? Unliquidated damages. Although some other remedies like injunction may be obtained in addition to the damages, or specific restitution may be claimed in an action for the detention of chattels. Detention of what? What is detention of chattel? If a cow trespassed your property, can you also detain that cow? If you detain the owner, it is a violation of his fundamental right. Article 21. You will go to jail. If you wrongfully confine a person, you go to jail. For example, a girl, dog came to your house. Just because it came to your house, you're detaining that. You detain the girl, is it? That is what chattels means. It includes dog, cow, and everything. Listen. Let's say a cow entered your property. A cow entered the property, destroyed your crops. Tell me, is there any violation of your right? Is there any loss suffered by you? Can you file a suit against the owner for recovery of compensation? Yes or no? At the same time, you also have a right to detain that cow unless until what is paid. That is the extra remedy. What if the remedy is only detention of the cow, not the compensation? Is it called as a tort? No. To call something as a tort, there must be a remedy for what damages? Unliquidated damages. And this is what differentiate other types of civil wrongs. Yes or no? What if the remedy is liquidated damages? Not a tort. Not a. Because tort means other than exclusive breach of contract, trust, or equitable obligation. What obligation? Self-help is also a remedy. One of the remedy available in case of what? Tort. In case of what? But main remedy is what? Unliquidated damages. What damages? Along with that, to have a self-remedy. Self-help. What is self-help? If somebody trespassed your property, you can evict him from your house. That is also one of the remedy, right? But along with that, what is the major remedy you have in case of tort? Compensation or a suit for unliquidated damages. Bolo bolo. Unliquidated damages. It does not apply to all the torts, and in particular, not applicable to trespass to the land. This right to self-help, right to what? Is not applicable for trespass to the land. Trespass to the what? Land. Why? Because self-help is not available to trespass to the land because nobody is staying over there. But if somebody trespassed your house, do you have self-help? Can you use some reasonable force to evict him from your house? Yes. But if somebody trespassed your land, do you have a right to file a case against him for recovery of compensation? Yes, there is a violation of your right. Violation of your what? These are the essentials of a tort. You guys know what are the essentials of a tort? Wrongful act or omission. Second one, legal damage. Third one, legal. If any one is not there, is it called as a tort? I will give an example. You guys should tell me whether it is a tort or not. I will give the legal maxim. Damnum sine injuria. Not a tort. Injuria sine damnum. Damnum cum injuria. Injuria cum damnum. Injuria cum damnum. Tort. Damnum cum injuria. Damnum cum injuria. Cum injuria. Tort. Injuria cum damnum. Tort. Yeah, but I'm interchanging the words. Okay. Injuria sine damnum. Damnum sine injuria. Damnum cum injuria. Injuria cum damnum. Injuria sine damnum. Sine or sine, whatever it is. Injuria cum damnum. Injuria sine damnum. Damnum sine injuria. Not a. Are you guys clear with this, everybody? Yes or no? What is the first essential element of a tort? Second one, legal damages. Third one, what remedy? Legal remedy. Let's discuss few case studies for the purpose of understanding this wrongful act or omission. Let's start. We have this case law called as Glasgow Corporation versus what? Taylor. What happened in this case, sir? Can anybody read this case? I'll make any one of you to read this case. Huh? You will read. Now next to Kirti. Read. You only. Shuru karo. Ready? 1, 2, 3. Start. Stand up and read. Wait. Which corporation? Did they fail to put proper fencing? Yes. Or warning around a poisonous? Continue. Peri allama. Berry bearing tree. What tree? Berry bearing tree. Growing in a what garden? Public garden. You know what is public garden? Tell me what is public garden. Lal Bagh is a public garden. Let's assume public garden Lal Bagh. In that Lal Bagh there is a berry bearing tree. What tree? Correct, right? Continue, beta. Continue. Your child, not your child. Sorry, a child. A child. A naughty child. What he has done? He plucked and ate the poisonous fruit. Oh my God. From the tree, from the what? Tree, obviously. From where he can pluck the tree? Fruits. From the tree, he plucked the fruit. What fruit? Poisonous fruit from the tree, and he died as a what? Result. Oh my God. Khuda. Whether the corporation was liable for the omission to safeguard children from the danger. Corporation liable or not liable? Too liable because it is a omission. They have a duty to protect, fence it because it is a poisonous one, or should give a warning saying that thing bedi. No, but there are trees where the trees are good but fruits are poisonous. No, we are not. We want all types of tree for education purpose. We also want people to know this is a poisonous tree. Right. They'll not put trees. See, first of all, should they have not put the tree in the first place? Yes, your contention is correct, but that is not happened here. That there is a poisonous tree. At least they should have given a specific warnings. There was no specific warnings. Child ate the poisonous tree and he is dead. Is it a wrong? Can you file a case against the corporation for recovery of compensation? Yes. At the same time, is the corporation also punishable under the BNS? Yes. Koi mar gaya. BNS also punishable. That's what the one who is in charge of that particular work will be held punishable because there is a negligence, criminal negligence, and somebody is dead, culpable homicide. Are you guys getting it? Is it an act or omission? Act or omission. So tort can be an act as well as the omission. Both are called as what? Tort. Can you guys read the decision as well as reasons? Read. Correct. Attractive but poisonous trees. Berry, red color. Huh. The corporation failed to fence the tree. Negligent omission. The duty breach was general duty of care imposed by the not arising out of any contract. If it is out of contract, tort law will not come into picture here. Which will come into picture? Contract act. Yes or no? The death of the child was a direct and proximate result of the corporation's negligence. That is why she can recover the compensation. Are we clear with this, everybody? Yes or no? Sit down. Very good. Sit down. Next one. General Cleaning Contractors Limited versus Christmas. What is that? Now Bhumi will read this. Bhumi, please read this. Stand up and read. अरे पैशन होना चाहिए भाई, थोड़ा एनर्जी दिखाओ भाई. Employer engaged, हाँ. Hey, nobody should. चलो रीड करो बेटा, फिर से शुरू करो. हाँ. Window cleaner. You know who is window cleaner? The one who cleans the windows is called as window cleaner. Continue. To work at a height. Next one. Is it the duty of the employer to provide adequate safety measures? Yes. He did not provide the adequate safety measures. Continue. Employee, he fell and suffered what? Injury. Is there any violation of right? Is there any loss? So there is an injuria cum damnum. Injuria cum what? Damage. Is the employer liable or not liable? Is it an act or omission? Wrongful omission. What omission? Tort can be an act as well as omission. Continue. Employer. Reasons. Non-delegable duty. What is non-delegable duty? You cannot transfer it to someone else. Correct, right? To provide safe place of work. Exactly. Same system of what? Work. Did he provide that? Is it a violation of right of the employee and a breach of duty by whom? Employer. And that gives a remedy to the employee to claim the what? Compensation. Are we clear with this? Yes or no? Next one. That is wrongful act. Next up. Can you guys read this case law, please? Next up. Who will read this case? Gloucester Grammar School case. What case? Gloucester. What case? And the case allama. Gloucester Grammar School case. What happened in this school? I will read this case. Listen, everybody. What happened? There was a beautiful teacher in a school. Beautiful teacher, sir. Beautiful teacher, lady teacher. There was a beautiful teacher in a school, intelligent and beautiful. All students are fond of the teacher. Like avರೆಲ್ಲ ಬಹಳ ಒಳ್ಳೆಯವನ ಮಿಸ್ ಅಂತ ಕೇಳಿದ್ರು ಅನ್ಕೊಂಡು they're very fond of that lady teacher. What happened? One fine day she got fed up with this school and she decided to leave the school. When she is leaving, all the kids are crying. They are saying, "Ma'am, please don't go. Please don't go. Please don't go. We can't stay here without you." But she says, "No, no, no. I have a plan to start my own school in front of this school." What she did, she opened another school. What school? In front of that school. And what happened? All the students left the school and they joined her school. Now the employer of that school or principal of the school filed a case against her saying that there is a wrong committed by this lady because she took all our students. Tell me, is it a tort or not a tort? Why not? She has not done anything wrong. She's also doing the business. You're also doing the what? Business. But is there any loss? but there is no injuria, but there is a damage. That is not sufficient. Damnum sine injuria. Attine injuria. Is it a tort? Not a tort, because there is no violation of legal right. What right? But what if while leaving the school she says, "Yen school is the dabba school. If you guys stay in this school, you guys gonna die, or you will not clear the examinations." Karke she has did some defamation. She did use some bad words. Because of this, students got scared and she followed. The students followed her and they joined her school. Now tell me, is it a tort? Because she did some wrong. She did a defamation. Did what? Without that, if she lives peacefully, students follows her, joins the school suffers the loss. Will it be called as a tort? No. It's a damnum sine injuria. A damnum sine injuria. Understood this case law? Gloucester Grammar School case. What happened in this case? Can you guys read, please? Defendant was earlier employed as a teacher in the plaintiff school. After leaving, when I say everyone should read, okay, that is the basic principle. After leaving the plaintiff's employment, defendant started his own school. Wait, what reputation? Good reputation. And stand. Will he succeed? No. Because there is no violation of what right? Legal right. समझ में आ गया? अर्थमाइंदा? मनसलाइचो? Okay, ठीक है. Next one. Chazemore versus Richards case law. Or case law? Chazemore versus Richards case law, where there is the damage but without any infringement of right. What happened in this case? Let's start. Plaintiff owned a mill that depend on an underground water supply. Andre underground, borewells water, underground water supply. The defendant on his own land dug a well and attracted underground water for lawful use. Means nam properly borewell it. What other person does, he also digs a borewell in his property. Now what happens, that underground reservoir, what happens, it gets diverted and it comes down. Tell me, is it a tort? Why no? There is a violation of what right? Legal right. Like how you have a right to dig a borewell in your land, he also has a right to dig a borewell in his what? His land. There is no violation of right, but there is a loss. There is a what? Is it a tort? Because to be a tort, there must be what? Right. Infringement of right. Injuria sine damnum. Injuria sine damnum. Are we clear with this, everybody? Can you guys read the full para, please? I want everyone to read the points. Read. A defendant on his own land dug a well and abstracted underground water for lawful use. As a result, the underground water. Ayo, the plaintiff claimed monetary loss. Will he succeed? Succeed? No, because it is not a tort. Because there is no infringement of right. Infringement of what? Next one. Aspirant versus what? White case law. Now, is actual loss important or only the infringement of right? In this case, what happened? A person had a right to vote, but that officer of that vote, one who was looking after the casting of vote, prevented him from exercising his right to vote. Is it a violation of right? Because you have a right to vote and somebody is infringing with that. And because of that, have you suffered any loss? No. The candidate whom you are supporting got elected, means he already won. You are supporting BJP. That candidate won with more number of votes, means because you did not cast the vote, there is no loss suffered. But still, can you claim compensation? Because there is a violation of right. Because where there is a right, you be just EB remedium. Below, you be just EB remedium. Where there is a right, there is a remedy. I want everyone to read this point. Your voice will come in the recording. Read. First point clear. You want me to explain the first point? No. Second point. Wait, wait. Have you heard about returning officer? The one who look after the election process is called as what? Returning officer. Continue. Who is the plaintiff in our case? As by is the plaintiff. Who is the defendant? Who prevented whom from casting the vote? White prevented the as by. Okay, as B. Next, continue. Plaintiff, nevertheless. Hmm. Is the tort committed here? Yes. Is the defendant liable? Why? Because there is a violation of right. Where there is a right, there is a remedy, irrespective of laws. Okay. Last case law. I think that's it. These are the case studies. What studies? Case studies for the purpose of understanding the essential elements of tort. Tell me what is the first essential element of a tort? Wrongful act or omission. Second one. What damages? Third one, legal remedy. Only when all the three conditions are satisfied, it is called as a tort. Tell me, damnum sine injuria or sine injuria. Is it a tort? Injuria sine damnum? Injuria cum damnum? Damnum cum injuria? Injuria sine cum injuria sine damnum? Damnum cum injuria? Injuria cum damnum? Injuria sine damnum? Damnum sine injuria? Injuria cum damnum? Damnum sine injuria? Damnum cum injuria? All these are called as tort. Understood? चलो अब हम डिस्कस करेंगे मेंस रिया. What रिया? You guys tell me what is mens rea? Conscious exercise of mental faculties by a person with the intent of accomplishing something is called as what? Mens rea. What rea? Is mens rea required for the purpose of commission of a tort? For a criminal wrong? What is essential? Mens rea. Because without a mens rea, a person cannot be held guilty. Correct, right? An act of a person cannot be considered as a crime unless he has what rea? Mens rea. What is mens rea? What mind? Guilty mind. What mind? Important concepts I want everyone to focus on. Listen, everybody. Rezano. Mens rea is a guilty mind. What mind? This person has done something wrong, that is why he is guilty. Or blameworthy mental state. What state? Blameworthy mental state. Liability is based on the principle that mere commission of an act is not sufficient to create legal liability. Mere commission of an act is not sufficient. What is required to hold a person for mens rea? Guilty mind. What, right? Guilty mind. The general principle is expressed in the maxim actus non fit rea nisi mens rea. We have discussed this rule in the PNS also. Actus non facit rea nisi mens rea means that act does not make a person guilty unless the mind is also guilty. The act does not make a person guilty unless the mind is also guilty. What is also guilty? Mind is also guilty. In the law of tort, mens rea does not necessarily mean evil or malicious intention. It only requires that mind must concur with the act. Intention is different, motive is different, intention is different, mens rea is different. Right. A person may not be having any motive, but if he does it intentionally or negligently or recklessly, it is called as what? Mens rea. Called as what? Is negligence is a mens rea? Recklessness is a mens rea? Intention is a mens rea? What is the difference between intention, recklessness, and negligence? Means you can purposefully doing it. You can foresee the consequences and you desire those consequences. That is called as what? Intention. What is negligence? You neither foresee nor desire, but you fail to exercise the due care which you are supposed to take either as per the law or as per the contract. That is called as what? Negligence. Called as what? What is recklessness? You does know the consequences of your acts, but you perform it because you take that risk recklessly, carelessly. That is called as recklessness. All these are called as what? Yeah. Let's say you're playing a cricket on the street. Okay, road ಅಲ್ಲಿ ಕ್ರಿಕೆಟ್ ಪ್ಲೇ ಆಡ್ತಾ ಇದ್ದೀರಾ. ನಿಮಗೆ ಗೊತ್ತು ಕ್ರಿಕೆಟ್ ರೋಡ್ ಅಲ್ಲಿ ಆಡಿದ್ರೆ ಏನಾಗುತ್ತೆ, ಬಾಲ್ ಹೋಗಿ ಬೇರೆ ಮನೆ ವಿಂಡೋ ಕುಡಿಬಹುದು. You may know that might damage the property of other person, but you still play it. And is it negligence or recklessness? Why it is recklessness? You know that it may cause harm to the property of other person, but you take that risk. ಏನಾಗ್ಬಿಡುತ್ತೆ ನೋಡ್ಕೊಳ್ಳೋಣ. Are you liable to pay compensation or liable to pay? Because we have what here? Mens here. Tell me, what is the principle of general rule principle of tort? Actus non facitria nisi mensitria. Bolo. Actus non facitria nisi mensitria means an act does not make a person guilty. Bolo. Unless the mind is also. If somebody comes and say, Ninu ಮೋಸ ಮಾಡಿದೆ, ನನಗೆ ಏನ್ ಮಾಡಿದೆ, ಹೇಳಿದ್ದೆ ನಾನು ಕ್ಲಾಸ್ ಬರ್ತೀನಿ ಅಂತ, ನೀನ್ ಬರ್ತೀಯಾ ಅಂತ ನಾನು ಕ್ಲಾಸಿಗೆ ಬಂದೆ, ಬಟ್ ನೀನ್ ಬಂದಿಲ್ಲ, ಇದು ಮೋಸ. ಬಟ್ ಅವ್ರು ಹೇಳ್ತಾರೆ ಇಲ್ಲ, ಆಕ್ಟಸ್ ನಾನ್ ಫೆಸಿಟ್ರಿಯಾ ನಿಸಿ ಮ್ಯಾನ್ಸಿಟ್ರಿಯಾ, ನಾನು ಬರಬಾರ್ದು ಅಂತ ಅನ್ಕೊಂಡಿರ್ಲಿಲ್ಲ, ಬಿಕಾಸ್ ನನ್ಗೆ ಹೆಲ್ತ್ ಇಶ್ಯೂಸ್ ಇತ್ತು. ಏನಾಯ್ತು? ಹೆಲ್ತ್ ಇಶ್ಯೂಸ್ ಆಯ್ತು ಲಾಸ್ಟ್ ಮೂಮೆಂಟ್. ದಟ್ಸ್ ವೈ ಐ ಕುಡ್ ನಾಟ್ ಕಮ್. You can use this word, actus non facitrium nisi mansitrium. Nisi, no sir, really? Actus non facitrium nisi mansitrium. For example, by mistake you fell on somebody, or you fall on somebody, and that boy started shouting at you, how dare you do this? Then you can say, brother, actus non facitria nisi mansitria. You'll be like, what? Have you gone mad or what? An act does not make a person guilty unless mind is also what? Guilty. Dekho, my mind is not guilty. Please go away. Please what? Go away. If you don't go away, I'll do something with guilty mind. What mind? Where I will have guilty intention as well as what? Guilty action. I will slap you. If I slap you, I know I'm slapping you, and I'm doing it consciously. It means what? I'm doing it intentional. Then it becomes a what? Wrong. Becomes what? Yes or no? Yes. Clear with this? What is the principle of wrong? Actus non facitria nisi mansitria. An act itself is not make a person guilty unless mind is also guilty. Mind is also. The act must be done with either wrongful intention or negligence. Bolo, wrongful intention or negligence. Unlike criminal law, what law? Liability in a tort does not always depends on what? Mens rea. Does not depends on what? Mens rea. There are cases. There are what? Cases where a person can be held responsible even when you don't have what rea? What rea? So we can classify the mens rea into two categories for the purpose of tort. What is the first one? Fault or state of mind is relevant, and fault where state of mind is not relevant. Clear? In few torts, what is relevant? What is relevant? Mens rea. What rea? There are few torts where what is not relevant? Mens rea is not relevant. No, sir, really? There are torts where what is relevant? There are torts where what is not relevant? So it is not always true that, yeah, there are cases where even if there is no mens rea, it can be called as what? Are we clear with this? Yes or no? So actus non facitria nisi mansitria is not always applicable for a tort. Let us discuss the tort. Where what is relevant? What is relevant? Menstruation. What are the first one? In several branches of law of tort, the state of mind of a defendant is relevant to determine the liability. Following are the tort where mens rea is essential element. What is the first one? Assault. Below. Second one. Third one, false imprisonment. Fourth one, deceit. Fifth one, malicious prosecution. And the fourth one, conspiracy. We will discuss all these things at the end of the chapter, but I'll give a brief idea about all these points. What is the first one? Assault. What is the first one? If I take this water bottle and if I move towards the saying that I will kill you, called as what? Assault. I am creating an apprehension in the mind of the other person that I'm going to apply a physical force on him. That is called as what? Assault. Called as what? Is mens rea required for assault? Yes. I would have done that action with the guilty man. Second one is what? Battery. What is battery? Any wrongful application of force without the consent of other person, however minor it might be, it is called as what? Battery. Called as what? Even slightly touching a person without the consent of the other person or without lawful justification, it is also called as tort. And the other person can sue you for compensation. Yes or no? But you must have a guilty intention. What intention? Wrong intentions. Yes or no? Yes. But if you simply touch a person, no, not at all. But if you touch with the bad intentions, it is called as what? Tort. So what is important for the purpose of tort in few cases? Guilty mind. What mind? What is the first offense? Assault, battery, false imprisonment, confining a person to one place without lawful justification. ಯಾರನ್ನೋ ವಾಶ್ರೂಮ್ ಅಲ್ಲಿ ಕೂಡ ಹಾಕಿದ್ದೀರ, ಬೇಕು ಅಂತ ಕೂಡ ಹಾಕಿದ್ದೀರ. Is it a tort? Is it a tort? Do you have mens rea here? Now what if ನೀವು ಅನ್ಕೊಂಡ್ರಿ ಯಾರು ವಾಶ್ರೂಮ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ, ಲಾಕ್ ಮಾಡಿ ಬಂದಿದ್ದೀರಾ? Is it a tort? No, no, no. There are few cases where intention is required. For wrongful imprisonment, what is required? Intention is required. What is required? Clear with this? Next one. Deceit. What is deceit? Cheating. And malicious prosecution. What is malicious prosecution? You prosecute somebody without baseless, like without any sufficient causes, and most important that you have an intention of spoiling reputation of a person. Then it is called as what? Malicious prosecution. What prosecution? Malicious prosecution. Is malicious prosecution is a tort? Yes or no? It is called as what? Tort. It's called as what? Tort. In these cases, what is important? What mind? Guilty mind. What mind? Next one. Liability without a fault. Without any what? In these cases, even if you don't have mens rea, it is called as tort. 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 There are a few torts where what is not required? Mens rea. Means actus non facitium, facitium, nisi, mensitria is not applicable for certain torts. What are they? Strict liability. What liability? And absolute liability. What liability? There are few liabilities where you would be held responsible without any fault. आप इतना केयर लिया है, इतना केयर लिया है, इतना केयर लिया है, but still you would be held responsible because a wrong happened. What happened? Have you heard about MC Mehta versus Union of India? All in gas leak case where many people were dead and he was held responsible even though there was no fault. That is what liability? Absolute liability. What liability? कोई जरूरत नहीं है. There is no requirement of proving the mens rea of a person for few offences and he would be held responsible ऐसे ही. That is called as what? No fault liability. What liability? No fault liability. कोई mens rea नहीं है, ಯಾವುದೇ mens rea ಇಲ್ಲ, mens rea లేదు, mens rea ಇಲ್ಲ, but still you would be held responsible. It is called as what? No fault liability. Bolo. There are certain cases under the law of tort where the mental state, follow, of the doer is irrelevant. In such a cases, liability arises even in the absence of intention, negligence, or malice. What is malice? Malayal. Malice means what? It is criminal intention, wrong intention, bona fide, mala fide, wrong intention. The liability is fixed. The liability is fixed. What is fixed? Liability is fixed solely on the basis of harm caused and not to the on the state of mind of a person. This principle is also known as liability without a fault or strict liability. They may ask you to write a short note on a liability without a fault or strict liability. Will you be in a position to write in the examination? You should start with the answer saying that actus non piscitria nisi mensitria. An act of a person cannot be considered as wrong unless he has what? Guilty mind. Understood? But are there any exceptions? That is called as what liability? No fault liability. Well, what liability? Example for this strict liability or absolute liability. Thus, under law of tort, mens rea is not always necessary for fixing the liability. For example, we have the Motor Vehicles Act. Which act? Where death or permanent disablement of any person has resulted from an accident. In case of accident, do you have any mens rea? In case of accident, will you have any mens rea? Why no? It's an accident. Accident means what? No mens rea. Will you have any intention of doing it? If you have intention of doing it, mens rea is there. It is an accident, but still there is what rea? Mens rea. So it means it is a crime as well as civil wrong. It will be punished under both. Is mens rea essential ingredient for tort? Required or not required? Not in all cases, but few cases what is required? Mens rea. Few cases mens rea is not required. It is also called as no fault liability. Below what liability? No fault liability. Are we clear with everybody? Yes or no? Now, till now we discussed how many concepts. What is the first concept? What is a tort? Who is the author has defined the tort? Salmon. There are a few other authors also, same definition, but we will not discuss this definition. What is the definition of tort? Tort, where the remedy is under a common law for an action other than exclusive breach of contract, breach of equitable obligation. Are all civil wrongs are tort? All torts are. And civil wrong, what is the remedy? Damages. In what code? Civil. In case of tort, what is the remedy? Unliquidated damage. But there can also be some other remedies along with this unliquidated damages. Are we clear with this? What are the essentials of tort? What is the first one? Wrongful act or omission. Second one, legal damage. And for that we have two things. Damnum sine injuria, injuria sine damnum, damnum cum injuria. And last one is legal remedy. What remedy? Is mens rea is an essential for a wrong? Yes. But however, there are few wrongs where what is not required? Mens rea. It is also called as what liability? No fault liability. You know? Or strict liability. What liability? Strict liability. Actus non ficitrium nisi mansitria. What does it mean? An act itself is not a wrong. Mind is also guilty. Understood? Yes or no? अब हम डिस्कस करेंगे kinds of tortious liability. What liability? There are various types of tortious liability. If you guys remember, we have learned this in your CSET. Correct, right? Let us discuss one by one. What is the first one? Strict liability. Below what liability? Second one. Third one. Vicarious liability. Fourth one. Vicarious liability of the state. all five or four are important concepts. What is first one, sir? Strict liability is also called as no fault liability. What liability? Even though you are not under any of the fault, still you would be held responsible because of certain circumstances, and you will be held liable to pay compensation. That is called as strict liability. This is one of the old concept of tort. Torts are famous in UK and US. They have very advanced tort law. What law? Advanced tort law. But in India, it's still a growing concept. What concept? And the number of judicial precedents which creates the original precedents are very less. Why? Because most of the laws in India are what laws? Written laws. What laws? Written law. Now, strict liability. What is strict liability, sir? When it is applicable? Strict liability is applicable when a person make use of a land in a non-natural way or unnatural way. If you make use of the land, if there is a non-natural use of land, what use of land? Non-natural use of land. And whatever stored in that land, if it escapes from that land and causes harm to any of the person, then he should compensate to the person who has suffered the loss, irrespective of whether he has taken reasonable care or not. It is called as what liability? What liability? Strict liability. It is based on the principle that whoever brings a dangerous substance, what substance? To his land, he keeps the dangerous substance at his land at his own peril. What is peril? Risk. If it escapes, if it was, and causes harm to any of the other person, he is liable to pay compensation irrespective of amount of care he has taken. That is called as strict liability. You know what liability? Strict liability. One more time. What liability? What is the first condition? What use of land? Non-natural. Bolo? Means it is not a natural use of land. Non-natural use of land. For example, keeping a puppy. Keeping what? What is puppy? कुत्ते का बच्चा. Why you guys laugh for everything? Did I say anything? Beta? No, did I say anything wrong? Kutte ka bachcha is called as what? Puppy. But there is nothing wrong in I am saying kutte ka bachcha, right? Kutte ka bachcha is called as what? Puppy. Keep. Is keeping puppy. Keeping what? Wrong. Is it a natural use of land or non-natural use of land? You are keeping that. No. You have a property land. In that land, you are keeping the dog. It's a natural use of land. Okay? Keeping a puppy is a natural use of land. But what is keeping a lion? Is it a natural use or non-natural use of land? Non-natural use of land. First of all, you should not do that. If you do it, you will be doing it at your own peril, means at your own risk. Unless until it escapes and does not cause any harm to the outsiders, chalega, we don't have any issues with that unless law permits it. But what if it escapes and causes harm, even though you have taken in reasonable care? Will you be liable to pay compensation? Yes. For example, keeping a puppy, keeping what? Sweet puppy, adorable puppy. Is it a wrong natural use or non-natural use? But what if you bring a ferocious dog, ferocious and which is like bulldog? Is it natural use or non-natural use? It has the habit of biting the human beings, barking at human beings, also biting the human beings. You have taken all the reasonable care, but still what happens? One day it break the shackles and break that, huh? It goes out of the house and bites the one who is passing by. Tell me, Is the owner liable to pay compensation? Not liable to pay. Did it happen with intention here? No. Negligence? No. Recklessness? No. But still he is liable to pay compensation. This is what called as strict liability. What liability? Strict liability. Is there any mens rea? But is the owner liable? Because of what liability? Strict liability. Was there any non-natural use of land? Non-natural use of land. Second one, did it escape? Did it cause an harm? Is the owner responsible? That is what called as strict liability. What liability? It is based on the principle one who brings a dangerous substance to his land, he brings it at his own peril. If it escapes and causes harm to the any other person, he will be the one who liable to pay the compensation, whether he has taken a reasonable care or not. Without escape is not a tort. What if you keep a ferocious dog? Lion can only be there in classroom, not. I would have focused on the line. The way she's laughing. Lion. She doesn't generally she don't laugh that much like because I said lion. He's expressing like Bhuwana, where is your friend? She's attending online, but she's not saying anything in the chat box. Okay, she's attending online, is it? Yeah, okay. Why? Okay. Emergency. For that, we have one more liability called as, I'll come to that one. Absolute liability. For that is why we have, because there was, for applicability of strict liability, one of the essential requirements is that it has to escape from the land. If it doesn't escape, and if the harm is caused in the property itself, not a tort, not a strict liability is not applicable. For example, you enter the house of a person, enter the what? House of a person, and you try to pet the dog, and it bites. Is he liable or not liable? Not liable. That is because of your own act. Yes or no? It is not a tort. Not a what? Tort. It should escape. It escaped. Whatever it is, it escaped from the place where it is kept. Yes. A tort. It should escape. Leave that particular place where it is stored. I'll give one more example. Let's say there are explosives are stored in a place, and if it explodes and causes damage to the other person's property, tort. What if a person enters the house, then explosion happens in that house? Not a tort, and is injured within the house. Not a what? Tort, because you entered the house. Yeah, it is non-natural use of land. At the same time, there are three conditions now. Should be non-natural use of land, it should be dangerous substance, and third one is what? It should escape and should cause harm. Then only what is applicable? Strict liability. What applicability? Strict. Doesn't matter. If it happens at the place where it is sufficiently warned, it is not considered as a tort. For example, let's say if it was sufficiently warned that these trees are poisonous, you still enter, you pluck the fruit and you had it. Tort or not a tort? Not at all, because he has sufficiently warned that it is a what substance? Dangerous substance. What substance are? Keeping dangerous substance is not wrong. You should make sure the others are sufficiently warned, or it should not escape. If it escape and cause harm, tort, and there is no requirement of what rea? Mens rea. And this was held in which case law? Ryland versus Fletcher case law. The principle of strict liability was first discovered in the Ryland versus Fletcher, Kirti Ryland versus Fletcher case law. What case law? Ryland versus Fletcher case law. I like to break things. Don't break a situation where I have to break the things. Okay? Yes. Ryland versus Fletcher. Bolo? Understood? Yes or no? What are the three essentials required for the applicability of Ryland versus Fletcher case law? What is the first one? Non-natural use of land. Bolo? Second one, it should escape. And third one, cause and harm. Is the one who brings the dangerous substance responsible with fault, without fault? Without any fault. That is called as what liability? Strict liability. What liability? So because whoever brings a dangerous substance, what substance? Dangerous substance, it is his responsibility to keep them at his own risk. He keep it at his own peril. Are you guys clear with this? If you bring firecrackers and keep it at home, and if while bursting the crackers, if it escapes and causes the injury to the neighboring person's property or to the person, are you liable to pay compensation? Not liable to pay. You are bursting the crackers on the street, and the rocket went inside the house of other person, and the person was sleeping. It went inside his heart, to his hair, and his hair is damaged. Is he a bald? Is he punished? Is it a tort or not a tort? Tort. I think I'll become a director soon. In direct. I'll make a movie for sure. Yeah. Are you guys clear with strict liability, everybody? What are conditions to be satisfied for strict liability? Non-natural use of land, escape from the land, losses to the other person. Then is that one who keeps it liable without any fault. That is called as what liability? Strict liability. What liability? Strict liability. Yes or no? Okay, now you guys will read. He is the one who is Ryland. Can you see this? I found his picture in the internet. Have a look at this person who was the reason for the rule we have. Strict liability. What liability? Does this person look strict? He looks strict. Does he look funny? How? In which angle is looking funny? Ab dekho. Is he stricter? Arey pagal. Listen. No. Arey, this can be defamation. This can be defamation. You. Sorry, Ryland. Sorry. Ryland, and I know you guys do it in materials. Huh? I think you would have done it for the ECIPL material. In that I have given my first page, there is my picture in that material. They would have done some decoration and all. Here. Pictures and all, you have done the already. And that will help to remember, because you have done that drawing and all. Okay. Can you guys read this, please? Ryland versus Fletcher case law. Read. Let's start. You guys, any one read, or all of us will read together? Okay, let's start. Ready? 1, 2, 3, start. The principle of wait. Subsidy is what? Absolute. Huh. Hmm. Wait. Either brings or accumulates on his land. Anything which, if it should escape, may cause a damage to his neighbor. He does so. If it does escape, he is responsible, however careful he may have been, on whatever precautions he may have taken to prevent that. That is what the principle which was given in the Ryland versus Fletcher case. The whoever bring a dangerous substance or accumulates a dangerous substance which may escape and cause an harm to the neighborhoods, it does it at his own peril. If it escapes and does cause the damages, he is the one who is liable to pay compensation. What station? Compensation. Is it an absolute liability? Yes or no? What are the conditions to be satisfied? For the purpose of applicability of strict liability, there are two conditions. How many conditions? And these conditions were given in which case law? Reed versus Leon case law. What case law? Reed versus Leon case law. In this case, the court has held that for applicability of strict liability, there are two conditions to be satisfied. What is the first one? Escape from the land. Escape from the water. And the second one, non-natural use of land. What use of land? If it is a natural use of land and if something happens, you are not responsible. It's not called as a tort. Unless there is mens rea. Unless there is what rea? So, no. For example, you are playing a song. You played a song in your home, in a music, like you have a music system. You played the song, normal decibel. You played the song. The one who was living next to your house, he heard the song. It's an emotional song. Because he heard that emotional song, he died. Are you liable to pay compensation? Or that person went into stress, severe stress? Family members. Yeah. If they know, then only they can file. What if, what if at midnight, in the midnight, you wakes up in the midnight, you bring some amplifiers, set them inside your house, and suddenly you play the song. And because of that, and persons are dead, like so many people dead. Tell me, are you punishable for this? Yes. Is it a tort? Liable to pay compensation? Yes. What if you did not have the intention of playing it, but suddenly it happened? You're trying to, something happened. There was some malfunctioning of the system, and it happened. Are you responsible or not responsible? Because it is a dangerous substance. What substance? Keeping amplifiers at house is a non-natural use of land. Soundless. Understood? Yes or no? If it is non-natural use of land, applicable. Natural use of land, not applicable. Now let us discuss. Exception to the rule of strict liability. What liability? They asked this question in the previous examination. Generally, they ask what is strict liability. Well, what is strict liability? It is also called as no fault liability. What liability? This rule was invented or discovered in which case law? Ryland versus Fletcher case law, where the court held that if anyone bring a dangerous substance to his land, or if he accumulates anything in this land, then is, and if it escapes and causes, if it escapes, it may cause an harm to the neighbor. He does it at his own peril. If it do, or if it does escapes and cause an harm to the neighbors, he is liable irrespective of how much careful he was or whatever the precautions he has taken. This is called as what liability? Strict liability. For applicability of strict liability, there are two conditions to be satisfied, and these two conditions were given in which case law? Reed versus Leon's case law. First one is escape from the land. Second one is non-natural use of the land. However, there are exceptions. There are what? Exceptions. There are a few exceptional cases where the principle of strict liability is not applicable. There are exceptions. There are what? There are exceptions or cases in which the principle of strict liability is not applicable. What is the first exception? Damage due to the natural use of land. Hello? One more time. What use of land? Tell me, keeping one gas cylinder at house, is it natural use of land or non-natural? And if that gas cylinder bursts without your negligence and causes harm to the neighboring property, will that be called as a tort? Are you responsible or not responsible? Natural use of land. No question of strict liability. And for normal liability, there should be what? Mens rea. There is no mens rea. Is it a tort? No. What if you store hundreds of cylinders at your house in the godown? And if it escapes and damages the other person's property, are you responsible or not responsible? Which liability? What liability? Water pipe installation in the building. Is it a natural use or natural use? The working of mines and minerals on the land, natural use in that particular mining area. What area? Mining area. Lighting of a fire in the fireplace of a house. What is lighting of a fire in the fireplace of a house? It is natural in the England, those areas where they do this fireplace. Have you seen these old movies, Rajkumar movies? Yeah, TV, and where they light the fire and they sit like this. They'll be doing this and they'll be talking to each other. And I think I've seen this movie, this scene in some movie. Something. Some movie. English movies is famous, right? Because there it is, they almost winter season ज़्यादा होता है ना उधर. That is why they have this fire place in their house, inside the house, which will make the house warm. No. Is that natural use of land? Some ಬೆಂಗಳೂರಲ್ಲಿ ಮನೆಯಲ್ಲಿ ಬೆಂಕಿ ಹಾಕೋದು natural use of land. ಅದು non-natural use of land. ಮನೆಯಲ್ಲಿ ಬೆಂಕಿ ಹಾಕೋದು. Next one. Necessary wiring for supplying the electricity light. Wiring, natural use of land. Building a swimming pool or water storage tanks for domestic uses. What use of land? Natural use of land. Keeping explosives in an open field, non-natural. Collecting molasses in a large quantity. Allah. Molasses is in case of sugar industries, a wastage. They make wine out of it. Wine out of that molasses. It's also by-product. We do it in ethanol, and this use this in costing, calculation of cost. It is a by-product, main product, by-product. No, ನನಗೆ ಗೊತ್ತು because I am from. ನಿಮಗೂ ಗೊತ್ತಾ? ಬಾಗಲಕೋಟೆ ಇದೆಯಾ? ಸರಿ ಬಿಡಪ್ಪ, ಆಯ್ತು. ನನ್ಗಿಂತ ಜಾಸ್ತಿ ನಿಮ್ಗೆ ಜಾಸ್ತಿ ಮಾಡೋದು ಸರಿಯಪ್ಪ. No, I don't get into arguments. I like peace. Establishing a reservoir for generating power on a residential land is a non-natural use of land. A non-residential area, natural use of land. Correct, right? Residential area dalli reservoir kattadu enagutte non-natural use of land. Are you guys clear with this? So if it is a natural use, what use? Is the principle of strict liability applicable or not applicable? Not applicable. This is the first exception. What exception? First exception. అర్థమైందా? అరే సార్, no. Online students, can I get a hi from you guys? Say hi. Not you guys. Online students, not offline students. Just to check whether you guys are attentive in the class or not. Let me see how many of you are actually present. Say hi. Or you can say whatever you guys want. Second one. What is the second exception, everybody? Huh? What is the second exception to the strict liability? Consent of whom? Plaintiff. If the dangerous substance is kept with the consent of the plaintiff, Ganesh Prabhu is saying hi, Vidya is saying hi, Sanjana is also saying hi. Namaskaram. Namaskara. 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 Who is that break fellow? Let's start. Consent of plaintiff. What are plaintiff? Consent of plaintiff. If the dangerous substance is kept with the consent of the plaintiff, the principle of strict liability is not applicable. आपने consent दिया है, आपने approval दिया है. Getting it? So because the consent is given, it is not called as a strict liability. Where the plaintiff has consented to the accumulation of dangerous things on the defendant land, the liability under the rule of R versus F does not arise. Such consent is implied where, this is what most important, such consent is implied where the source of danger is for the common benefit. What benefit? दोनों persons का benefit के लिए वो dangerous substance रखा है. It means he has given the consent for it. Even if he has not given consent for it, it is deemed that he has given the what? Consent for it. When a dangerous substance is kept with a consent, principle of strict liability not applicable. Applicable? Not applicable. No, applicable, not applicable. Not applicable. Are we clear with this? What is the first one? Damage due to natural use of land. You know what use of land? Natural use of land. Second one, consent of what? Plaintiff. Third one, act of third party. Act of what? ఎవరో వచ్చేసి ఏమో చేసి వెళ్ళిపోయాడు. ఏం చేసి దానికి తెలియదు. వచ్చాడు, ఏమో చేశాడు, వెళ్ళిపోయాడు. Because of that reason, something happens to the other person. Is the translation? I'll do translations. A person comes and he does something and I goes away. Because of that, the escape happens. Means that goods, dangerous things escapes. நான் என்ன சொல்ல போறேன்னா, Vinu. Vinu is Telugu. கேளு. ఏమచ్చి అన్న ஒரு பேர் వచ్చాడు తెలుగు తెలియని इंग्लिश ఓన్లీ వెయిట్ हिंदी एक आदमी आता है आने के बाद कुछ करता है वो करने के बाद कुछ होता है तो कुछ नहीं होता है a dangerous substance escape होता है because of that third party. Is the strict liability applicable? Not applicable? Not applicable. कोई अरे वेट कोई अजनबी आके कुछ करता है वो कुछ करने का वक्त करने से वो डेंजरस गुड्स एस्केप होता है और हार्म करता है द अदर पर्सन. That will not be considered as a strict liability because it is not happened because of the plaintiff, sorry, defendant. It happened because of third party. What party? Third party. Hmm. Huh? Vicarious. In this case, if that goods was given to the servant, that the official, then he would be responsible as well as that shop owner is responsible. We have a concept called as vicarious liability, where for the wrong of one person who is held responsible, other person is held responsible. I'll come to that one. I'll discuss there. Okay, interesting concept. Partnership firm, agents, servants, independent contractors, master and servant. There I'll discuss. Okay. Now, First exception. What is the first exception? Natural use of land. Understood? Second one, consent of plaintiff. If something is accumulated or brought on the land with the consent of the plaintiff, and if it escapes, principle of strict liability is not applicable. Third one, act of which party? Third party. Act of which party? If a harm has been caused due to the act of stranger who is neither defendant servant nor agent, nor the defendant has any control over him, the defendant will not be liable. However, if the act of stranger is or can be foreseen, this is important, it can be foreseen by the defendant and the damage can be prevented. What can be prevented? The defendant must by due care prevent the damage. Failure on his part to avoid such damage will make him liable. He can foresee that somebody can enter his house and they may make it escape. You should take a proper care for that. You should fence it or should add it. Correct, right? Now, what if it is not done and if it escapes and cause the harm, even though it is done because of third party? Is it responsible? Not responsible? Responsible. Why? Because you should have taken the what care? Reasonable care. What care? Can you guys read this, please? Example. I want everyone to read. A as a bull. Wait. A as a what? Is it a cow or a bull? Bull means bull, not cow. But cow includes what? Bull, some cases. Some cases, cow is a general word. Bull is a male. Generally, we refer cow for the both male as well as female. That is why. Yeah. So express mentioning of one thing excludes the other thing. Rule of interpretation. What of interpretation? Rule of interpretation. For example, array. Listen. For example, if the washroom says she, only she. If the washroom says he, only he. Express mentioning of one thing excludes the what? Other thing. You cannot say he includes she or she includes he. But what if it says she or he? Both. What if it stands? Or in the flight they say lavatories, right? Then it is, in that case it is what? Anybody can use it. No. Express mentioning of one thing excludes the what? Other thing. Just washroom is mentioned. That's it. Nothing else is mentioned. Who can use it? Men as well as women. But if it says men, only what? Men. Women. You cannot say who. Men is also there. So bull here means only bull. Okay. Rule. अरे हंसने का नहीं है. ये इंपॉर्टेंट सीरियस बात है. मैं फनी में से बोल रहा हूँ. इतना ही है बस. और नाम को समझ लीजिए. ठीक है. मैं कोशिश कर रहा हूँ आपको कुछ बोलने के लिए. पढ़ाई करो. ये as a bull. Who as a bull? ये as a bull. Tied in garden which is properly fenced. मतलब वो reasonable care लिया है. वो reasonable care, yes, you have taken the reasonable care. Be a passerby, opens the fence. Nonsense fellow. And the bull is on the water. Loose. Oh. Bulls ends up eating whom? See. Then who comes to that spot? CSR. This example is there in your ICSI material also. It is not my example, sir. CSR comes and stops the what? Bull. It tames the bull. Now, in this case, is A responsible, not responsible? Not responsible. Why? Because it is an act of which party? Third party. Yes or no? Are you guys clear with this? When you guys concentrate, you guys will start interlinking with some scenes. Now you'll never forget this example, Nanish, because you interlinked with that movie. So you have to pay attention in the class. Done. This is the third exception. Not exception, third exception. I come and save not bull. Why will I save the bull? I save the person. Yeah, person, the lady. A will not be liable under the law of tort since he had taken due care for the safekeep of the what? Bull. We have 3 more exceptions. I'll discuss, then we go for a break. Statutory authority means if a government is performing some functions for the benefit of the public, benefit of who? Public. Principle of strict liability is not applicable. Have you seen water tanks in the village side? Big tanks. That is for whose benefit? Public benefit. If it escapes and cause harm to the public, are they liable to pay compensation? No, because they're performing what function? Statutory function. And what function? Sometimes public bodies storing water, gas, electricity, and the like are by statute exempted from the liability so long as they taken what care? Reasonable care. Can you guys read this case study, please? Read myself. Celsius Watches Works Company. हाँ, संग में पढ़ाई करेंगे. Let's start. A defendant company had a statutory duty to maintain continuous supply of water. A main belonging to the company burst without any fault on his part. As a consequence, plenty premises were flooded with water. It was in the example sudden bursting of water. If they have taken a due care. What care? ಇದು ಬರ್ತಾನೆ ಇದೆ ಹಿಂದೆ. In the of God, act of. What is act of God? Mukunda, oh my God. Oh my God is act of God. Movie. That is oh my God, yeah. Mukunda Murari is a remake of Act of God. Sorry, oh my God. Oh my God is a remake of some English movie. It's also not original movie. Akshay Kumar's Oh My God is it, right? That is a remake of English movie. First it came in English. They copied it in Bollywood. For Bollywood they call it copied in Telugu. Telugu. Telugu ಏನಂತಾರೆ? And Gopala. Tollywood. Then it came to Sandalwood. Mukunda Murari. Oh my God, 2 also came. It's not good. Okay, I didn't watch it. Okay. Anyway, see, if the act happens, the escape was due to the act of God. What of God? Act of God. Is the principle of strict liability applicable? What is act of God? Example, natural calamities, earthquake, volcanoes. All these are what? Natural calamities. What calamities? I have built a reservoir in my land, in my properties, the purpose of storing the water. I have taken all the reasonable care. But because for the first time a person is doing some good thing, what happened in that particular year? So much of rainfall happened, like it is beyond expectation of any reasonable man. So much of rainfall, because of that, the reservoir got filled and it burst and it floodgates opened and it destroyed the property of nearby places. Am I responsible? Not responsible? Because it is not an act of CS, it is an act of whom? God. Act of whom? Window open ಮಾಡಿದೀರಾ? Then why that flickering is coming? Okay, fine. Are we clear with this, everybody? If it's an act of who? God. Act of without any human intervention. Is the principle of strict liability applicable? No. No means. Next one, escape due to whose fault? He only goes and he only unleashes the dog and it bites him. ನೀನೇ ಮಾಡಿದ ये आपका ही गलत है इसीलिए आपका पनिशमेंट भी मिलेगा. Principle of strict liability is not applicable. Are you guys clear with this, everybody? If the damage is due to the cause or due to the plaintiff's own default, was considered to be good defense in Raleigh versus Fletcher itself. Also, if the plaintiff suffers damage by his own intrusion. What is intrusion? Intrusion means entering, interfering. Intrusion to the defendant property, he cannot complain of what? Damages so cost. What cost? Damages so cost. Yes or no? Yes or no? I'll give an example. Just imagine I wanted to add all these things, but yesterday only I finished this. I could not add all this incident. Otherwise, I would have made it look like a some movie. Time Nagita. But next time I'll do it. Just imagine I'm a thief. Who am I? Thief. I'm saying something in a dignified way. Thief. And she's saying Kalla. चोर और कुछ है defamation. Yeah, I'm a thief. I want to steal something from your house. Midnight, 12 o'clock. I come in front of your house. You have a dog. Dog start barking. I will do. I throw biscuits. Dog eats it. I'll come. I'll pet it like, oh, so jao beta, so jao. Then I break the door of your house. I will not break. I'll jump the compound first. Then I clean with the help of that pipes. Then I'll enter your balcony. Enter the what? Balcony. And I break the door of that balcony room and I get an access to your house. You get an access to your house. All of you are sleeping. You're in a deep sleep, thinking that you have so much of money in your house and you're happy. I enter the house. I take all the valuables. Now I am happy. Who is happy? Yes, that I'm going to be rich. From tomorrow onwards, I will be a rich man. I'll pack everything. One side, all the gold jewelries. Other side, cash. You guys had 5 crore rupees of cash in your house. All 2,000 rupees notes. I'll carry. I feel I'm carrying both with so much of happiness. Like, yeah, I'm just trying to imagine tomorrow I'm going to be a rich person. No, dog is sleeping. I was about to leave the house. I was feeling thirsty, like I want to drink water. So I see a wine bottle. What bottle? Wine bottle. Thinking that it's a wine bottle. What bottle? I consumed that whatever was there in that wine bottle. I consumed it. And when I was about to leave, what happened? I got unconscious. Suddenly you woke up and you saw like, sir, you. And I'm like, me, me. And I was, you, why are you here? You'll ask the question, I'm like, why are you here, sir? Then I'm getting the dizziness and I'm about to fall. And I'm holding both whatever I got, the stolen property in my hands. And I fell. After seeing that I was stealing the property from you, did not even help me. You did not help me to take to the hospital. I suffered. In 1 minute only, like in a fraction of a minute before you think, I suffered and I died in front of. Police comes, my legal representatives comes and file a case against you saying that these people poisoned CSR. Poison who? CSR. आप compensation दे दो, क्यों नहीं देंगे? You're supposed to give me the compensation because you kept a poison in your house. Who will keep poison at house? Why it is my fault? Drank it voluntarily. Yes or no? If something happens because of whose fault? Plaintiff fault. Whose fault? You thought I was dead, but I was not dead. I recover. I what? Recover. I recover after some time and I file a case against you for recovery of compensation. Will I succeed? Is it a dangerous substance? Natural use, non-natural use. Non-natural use. But It is happened with the by the fault of whom? Plaintiff. Fault of whom? Plaintiff. That is why principle of strict liability is not applicable. Clear with this? These are the 6 exceptions to the principle of strict liability. समझ में आ गया? What is the first one? Natural use of land. Second one, consent of plaintiff, expressed or implied. Third one, act of third party. Fourth one, statutory. And the fifth one, act of, act of, act of. The last one, plaintiff's own fault. Are yes or no? Are you guys clear with this? Everybody, we are done with strict liability. अब हम discuss करेंगे absolute liability. What liability? One more interesting concept that we will discuss after the break. After the what?